In the wake of considerable layoffs announced by prominent corporations such as Google, Tesla, and Walmart, a significant number of H-1B visa holders find themselves facing uncertain futures. Recognizing the challenges faced by these immigrant workers, the U.S. Citizenship and Immigration Services, USCIS, has issued new guidelines aimed at providing clarity and support for those who have been terminated from their employment. H-1B visa holders, often employed in high-tech jobs, are particularly vulnerable in times of economic downturn due to their immigration status being tied to their employment. In response, the USCIS has outlined several options available to these individuals, allowing them a chance to extend their stay in the U.S. beyond the typical 60-day grace period afforded following job loss. Among the options laid out by USCIS, H-1B visa holders may file for a change of non-immigrant status within this grace period. They can also apply for an adjustment of status or for an employment authorization document, EAD, under compelling circumstances. Additionally, they can become the beneficiary of a non-frivolous petition to change employers. The agency emphasizes the concept of portability, which allows eligible H-1B non-immigrants to transition smoothly to new employment opportunities, permitting them to begin work with a new employer as soon as a non-frivolous H-1B petition is filed on their behalf, even before approval. For those eligible to apply for immigrant visas through self-petitioning, concurrent filing of their petitions with applications to adjust their status is possible. While their adjustment applications are being processed, these workers can remain in the U.S. and may acquire an EAD. Moreover, USCIS clarifies that beneficiaries of approved employment-based immigrant visa petitions facing significant challenges could be eligible for a one-year EAD, facilitating continued employment while pursuing lawful permanent resident status. This guidance from USCIS comes at a critical time as the tech industry continues to experience widespread layoffs, with over 237 tech companies having laid off 58,499 employees so far in 2024. The USCIS's latest statement serves to correct misconceptions, highlighting the avenues through which laid-off H-1B visa holders can legally extend their stay in the U.S. These include filing for a change of status, adjusting status, applying for a compelling circumstances EAD, or becoming the beneficiary of a petition by a new employer. Additionally, H-1B non-immigrants are reminded that if they choose to leave the U.S. following job loss, their employer is responsible for paying for their transportation back to their home country. For those considering this option, it's important to note that they could return to the U.S. if they secure another job and comply with the necessary immigration requirements. As the landscape for immigrant workers in the U.S. continues to evolve, staying informed about legal rights and options is paramount. For H-1B visa holders, understanding the broader array of choices available following job termination is crucial for making informed decisions about their future in the United States. For further details on navigating the complexities of H-1B visa regulations and staying in the U.S. legally amid job changes, visit visaverge.com.